Guiney is here to tell you about asking any questions you want of her after it's done. She'll answer them to the best of her ability.
Hey guys. So Mark, I thought after the speaker, absolutely, I love this pilot program. I think it's got some very positive things I wanted to point out to you guys. But of course, it's in the middle of the afternoon, and I don't want to talk for an hour about scheduling and the way that we run our docket. So I'm going to give you guys, if you haven't been in the course for 25 of them, you do the pilot program, a real brief overview of how it works, why we are opting to do this, kind of where I think it's going in the future. And then last year when I spoke, I had an opportunity to just kind of turn questions over to you guys. As long as you can promise to be civil, I will answer anything that you guys have. But keep in mind, I only speak for myself. There are, as Justice Brown said, 22 very distinct personalities in the felony courts, running the felony courts as judges. So, but questions, comments, criticisms, please feel free when I finish. So, the pilot program that we started last September is called Differentiated Felony Case Management System, because there are not quite enough acronyms in our building. We call it DCM for short. It has settings that have different names than what you may be commonly used to, and I'll go over those with you in a minute. The reason that we started this program is because across the board, everybody, regardless of whether you do prosecution or defense or refer to judiciary, recognize that what is going on and what has been going on in our courthouse isn't working. The traffic flow patterns are out of control. Defendants are being brought to court far more often and far more frequently than they need to. Things aren't being done efficiently, so we started looking elsewhere for what works in other jurisdictions. And Tarrant County has a system that we chose to model our system after. There are some inherent differences that we can't account for, we can't fix. Things that are dependent on things like intake. We have a very different intake system. We have an intake system versus Tarrant County that doesn't. And so ours is a rough model. We started touring last year to talk to people about what it was that we wanted to do. And it was so divergent from anything that had been done before, we recognized at the onset that there were going to be grumbles. And sure enough, there were. Most of you in this room have been practicing law longer than I've been alive. We are, as a group, very set in our ways. And so the change was sort of dramatic, and there were large grumbles. But we knew that that was going to happen, and we told everybody across the board before we implemented the system that if you saw something, rather than just do what we always do, which is complain to each other in the corners of the courthouse, that if you would approach us and address the issues, that we would, to the very best of our abilities, attempt to fix them. And the reason for that is pretty logical. I mean, I sit on the bench all day. I take the bench at 9, and I don't get off until the very last case is disposed of. But there are aspects of the courtroom where I never am. I'm not in the holdover. So if you have a holdover issue relative to this system or any other system, I'm not going to know about it unless you tell me. So, that being said, how many of you have been in the court? These are the 5 courts that are on the system. Judge Patrick, myself, Judge Susan Brown, Judge Hart, and Judge Kavanaugh. Has anybody not been in any of these courts? This is completely free to you. All right, so a couple. What happens, for those of you that haven't been, or for those of you that haven't been very often, typically, I have my docket days on Thursdays. It doesn't mean that I get to escape the other 4 days per week, but I set the majority of my cases on Thursdays. So Thursday docket is about 100 cases. We have staggered dockets, which means when you get a reset, as long as you're not one of the last ones to get the reset for the day, the coordinators in every court, I think, except for Judge Kavanaugh's, will give you an option of 9, 10, or 11 o'clock docket. It's kind of nice. It allows you to plan your day a little bit better, so that you know that if you take an 11 o'clock docket setting in my court, I'm not expecting you there until 11. I do expect you to go to 30. No problem. So they're staggered dockets, first off. 9, 10, and 11, please are set at 9. Clients who have had their cases reset after bonding out who have not come with a lawyer are set at 9. The rest of the cases, it's really a free-for-all for whatever you want, whatever works best for you. We try to stagger them so that it is in line with the jail standards, so that there aren't too many people in the holdover at any one time. So there may be, I don't know how the coordinator does that in terms of county asylum. at least one extra deputy to handle the jail traffic and moving folks to and from the jail and the courtroom. Sometimes we have an extra CLO who handles things relative to probation, and I try to have an extra clerk because I refer to my daily docket. I don't know what anybody else's daily dockets look like on their docket days, but mine is an exercise in controlled chaos. It's not overly loud. The gallery is crowded, but we move through an enormous amount of cases. Not in a sort of McDonald's justice system. I don't want to apply that, but I mean, we do handle a great deal of cases. The flip side is, on the days where I'm not in docket day, so Monday, Tuesday, Wednesday, and Friday, I can deal more with my MAJs and my MRPs, and I can spend more time talking about those cases and what an appropriate resolution is for those cases, in a way that I never saw in a regular. If your regular docket is 50 to 75, realistically, you're not having the time, especially if that court happens to be in trial, which most courts are in trial a fair bit. The other thing about the system is that while I'm never in trial on Thursday morning, if we're in trial that week, I'll tell the jury to come back at 1, so we still get a full 4 hours of testimony in, or we just skip Thursday, depending on where we are in the trial. But the other days, Monday, Tuesday, Wednesday, and Friday, it allows an enormous amount of continuity for the trial. We're not breaking as often for pleas, we're not breaking for interruptions, and that sort of thing. So I found that the trial actually goes faster, the jury really enjoys not having to be escorted in and out of the courtroom every hour or so. Today I was done, I had 103 cases on the docket today, I was done by 12:35. I think the latest I've ever gone is 1:30, and really that's because people get there, if you don't get to court until 12:45, you're probably going to be a little late. So I know that this is kind of hard to see, but the system is, in its purest form, the system is set up on a tracking system for cases, and there are 3 separate tracks. The basic, which would be UUMVs, evadings, mainly your state jails, drug cases, PCS less than a gram, those types of cases. The majority of cases are going to be in the basic track. Burglaries, where maybe there's no DNA, assaults, aggravated assaults, where there's not an enormous complex medical set of records that need to be examined and whatnot. And then the complex, which is the one that allows for the lengthiest time between resets, is murder, sexual assaults, the cases that really take a lot of time. Nobody in any of the courts, at least that I'm aware of, are applying these setting timelines to capital cases. The thought behind this program is that you come to court less often, you are granted more time between the court settings. I know when I was doing defense work, there was nothing more frustrating than those couple of courts that had every 2-week settings. When you're waiting on stuff, right? I got it. Because if you're waiting on DNA, there's really no reason for you to come every 2 weeks, because it ain't coming. So what happens is that cases comes in, and we call that the initial appearance. It's just the way we categorize the cases. From then, it's automatically reset for 30 days. If they bond out, great. If they don't bond out, they're still dealt with in the same 30 days. But always on whatever particular docket day that court has. From then, if it comes back in a 30-day setting and it already has been indicted, then it continues to move along the process. The system, the main date for calendaring in this system is the indictment day. And so once the indictment day happens, then the pretrial conference day is 90 days roughly after that. Whereas a lot of the courts, and I know in the past, you kind of get a bunch of interim settings, so it's not unusual to have 10 non-issue settings or 10 disposition settings, whatever terminology that court uses. This system, and we've all sort of agreed so that we can have an accurate measure of how we're doing, we've all agreed that not to have 3 consultation settings or 2 consultation settings, that if we needed additional settings before the case was disposed of, we would back end them, have more what we call a comprehensive pretrial conference setting. That's the idea behind the program. We started in September of last year. Like Justice Brown was saying, even within the 5 of us that are on the DCM program, there are some pretty remarkable differences. I know in Judge Brown's court, and if you are an in jail, in custody defendant, and your case is not indicted, you fall off the docket until your case is indicted, and then it gets back on the docket, which may or may not create some scheduling issues for criminal defense attorneys, which is why I choose to just estimate when I think the case excited relative to what kind of cases. Drug cases, especially in particular agencies, are going to be closer to 90 across the board. Sexual assaults are going to be closer to 90. If it's a UUMB, it's probably going to be indicted, 45. And it plays out all the data for us to look at about what is relative given the office. So, there are 2 forms that came with this program that we sort of adapted for our use in Harris County, but after using them for the first couple of weeks, I found that they were not as helpful as they were intended to be, but there are some courts of the 5 of us that still use the forms. Really, they're more meant for everybody to be on the same page. Are we going to need a translator? Have you asked for everything that you're entitled to? Have you gotten everything that you're entitled to? The sort of just checklist things, how long that you anticipate the case to last, those sorts of things. But originally there was a lot of complaints, and that's well founded. They were exactly what we thought, which is it's hard to change course completely. It's hard to get people out of their comfort zone, and it's hard to adjust the system that's really been in place for an extraordinarily long time. As we worked out the kinks and as we addressed the problems that were brought to our attention, sort of real time, we've kind of hammered out some things, and I think that on the whole, I've received nobody has a problem complaining to me. I'm not saying that there aren't complaints. There are going to always be complaints. But I don't hear as many complaints now as I did, say, in October of last year, which tells me hopefully that the system is working and that people are getting used to it. I also, instead of not hearing complaints, I've heard some positive things. That may not be your experience with the system, but I certainly hope it is. What we have found in terms of time to disposition in cases is that in the middle there, so like from the 61 to 90 days of the case age to about the 180th, I think, the DCM courts move more cases. So the goals set out by the National Council of Judges and the people who are looking at my work and I'm sure quarterback the way we run our courts, it is the goal to have cases brought to trial within a year of charging. Obviously, that's not always possible. And given my current trial calendar, that's impossible because I have cases on my trial calendar already that are more than a year old. In terms of actual settings, what we found is that the DCM courts, have about 1 less setting per case than the other courts. And that may not seem statistically significant, but it is, as you all know, especially if you have an on-time defendant working an hourly job and he has to leave that job to come down to the court, that is significantly significant. That is significant in that it is reducing the time that he spends waiting for nothing to occur in large amounts. So, I'm sorry to read the numbers and all that. Our average for the DCM courts, at least in July of this year, we were averaging about 5 settings per case. The non-DCM cases, the non-DCM courts were averaging 6.1 settings, so a little over 1.1 settings per case. So, we have tried, Judge Brown, as the administrative judge, has tried to bring others on board because there was so much troubling and so much skepticism in the beginning. There have been some judges who've been hesitant to dip their toe into a pool that may get them grumbled about. There are also people who have the dockets they feel are completely manageable in the way that they're running them now, so they don't want to tinker. There are also people who, like the rest of us, are set in their ways. Instead of now trying to encourage people to get on the one-day docket system where the majority of your cases are calendared for 1 day per week, what Judge Brown and I are trying to encourage our brethren to contemplate is whether or not they might consider adopting the scheduling orders and the scheduling plans that are relative to this program, because there are 2 reasons. One, you would have less settings, you would have greater time between your settings, and there is something valuable about consistency. And so regardless of whether you have a client in the 174th or a client in the 179th, you could reasonably say, these are the times you're going to be coming to court, as opposed to you're going to be coming to court every 2 weeks. And so there's something about that that is nice, consistent. We're not ever going to get all 22 of us to agree on anything, so we'll do what we can. There are a couple program is predicated on the idea that attorneys don't work out their cases in court necessarily, but that they're working on those cases outside of court. Let me first say, before I get any further, I realize this is a two-way street. We've had this conversation with the district attorney's office before. I am not suggesting to you that I believe that you alone can do anything to negotiate the cases if the DAs are not returning your phone calls or answering your emails, okay? But when I give an attorney, it's not unusual for me to give an attorney a 6-week or 2-month setting between today and their next setting. Clearly, I'm thinking that you're going to be accomplishing things, and that goes for both parties. I'm thinking that you're going to get the records that you told me have been ordered or aren't in. I'm thinking also that you're going to have an opportunity to review those records and go over them. Get an offer from the state, convey that offer to your client, do those sorts of things, not within the confines of my courtroom on a crazy, hectic, busy Thursday, but outside of that. I remember how difficult it is to get people to return your phone calls and emails, so we try to do everything that we can to make the process easier for you guys. On the Just Text website, and I think I told you guys this last year, but for those of you, I didn't have a thing, and I wasn't very good about explaining what the website looked like. So, for those of you that are not familiar, this is the county court website, justtext.net. On the left-hand side, you'll see at the top. Not mine. Go on. Where it says courts, you click on that and it'll take you to family courts, civil courts, criminal courts. Obviously, click on criminal, it'll give you all 22 of us. I clicked on mine because mine is up to date. Those hyperlinks under the prosecutors assigned to the court will take you to who is assigned to the 179 as of today. I try to keep this updated. It includes my special prosecutors for the divisions who have assigned courts within their divisions. Obviously, it doesn't include people in major narcotics who kind of float, or ID theft who float in all the courts. But this is a good stepping stone. If you're practicing in courts that don't have this, you should encourage them to do it because it takes about 2 seconds from their desktop. I can do this for the prosecutors, but what I can't do is provide you all's address to the prosecutors. So that I encourage people to use this, even as a way just to let the prosecutor know what your address is, so that if something comes up, they can email. I mean, everybody's got a smartphone. You can work on cases at lunch, if you want to, I guess. I'm not really encouraging that, but, so this is the first step. The system will not work. And I know that some of the other judges and myself included, it's very frustrating when I said, okay, why do you need a reset? Oh, I just haven't gotten this done yet. Why didn't you get it done in the 2 months that I gave you beforehand? I understand that things come up, and I think realistically what happens, and I've had attorneys tell me this very earnestly and honestly, is it just kind of fell off my radar. And that is the nice thing about having 2-week settings, is that it constantly keeps those pieces on your radar, even if it's inconvenient. So, that's that. In all of the courts, you'll be made or asked to approach the judge to set the case for trial, to get another setting if you are at pre-trial conference and you're not ready to set it for trial, or the state's not ready to set it for trial, and you'll be told to approach all of the judges. They just want to hear what it is you need, how long they think it'll take to get there. One of the other complaints that I heard from the other judges when I asked if they had anything they wanted me to share with you all was that it isn't unusual, and I'm really open to suggestions because I've actually liked to fix this. The DA's office has tried to, when they have things that records and whatnot to turn over to you guys, they leave them on the 4th floor. It isn't unusual for the DAs to make those things available, and they sit there for weeks. And so, I mean, I don't know if maybe it would be easier if they were bringing them to court with them.
Yep.
Is that?
Yep.
Yes. I mean, I don't exactly know why they don't do that, but
I think it would be easier if they brought them to court. Then you have the personal relationship. You have the piece of paper that you've been waiting for, and you look at Beth and say, Beth, I want 5 on this. Can you give me 5?
well, I appreciate that. Anything else along those lines that you think makes the whole system better? Yeah, Terry. Okay, some of you, to be clear, that's a completely reasonable request. If you do hear Carrie, she can
What'd she say?
Carrie said that it would make it easier for you to retrieve the records if you were notified those records were ready. As opposed to just constantly going down and trying to I think that's a very reasonable request. So a completely neutral observer. Some of you write like you're serial killers writing your information is not up to date with the state bar, and you're like a leaf floating in the wind. Some of you are hard to track down.
And I'll tell you, in your court, I mean, email parents like, oh my gosh, I don't have this, and I'm like, oh, my client, you should just scan it and email it to me.
Just the blue ones. Right. And realistically, and also, as I've talked to defense attorneys who didn't want to quite sell out the state of the bench, which I don't understand why. I might disagree with them at that point if I were in their shoes, but, if you send an email like that, requesting a response and you don't get one, you have a record for your file that a request has been made, and if inquiry by the judge, you can say, I've tried, what do you want me to do? Yes, ma'am, what?
I was actually gonna say the same thing, because I've sent emails and just don't, some prosecutors are very good at it. In fact, most prosecutors are very good. If you leave a paper trail on, that they're gonna at least try to see why they didn't do something back. But one of the problems I have is even if they left it on the fourth floor and you go get it, they still don't know what mail is in there.
What do you mean?
Like they look at it.
Like they haven't read it.
And so like, what was the whole point of me spending all that time? And so then, the thing that concerns me, I've noticed, that I don't think is fair, and I hope that you, as judges, get your coordinators to do this. Every reset says defense request. And so whenever we go upstairs, something is completed, it looks like we're the ones who are asking for the recess, when the truth is, the prosecution wasn't prepared, and it is difficult for us, we legitimately need to reset for something, you're like, no. And so I have to like go to the coordinators and be like, okay, do I need to approach the judge on this? Because I didn't do this, it's just gonna be become prepared.
Right.
And I think that's really important.
You know, I mean, in terms of CYA, I think that an appropriate thing for you to do might be, if you weren't able to talk to the judge, or the judge was in trial, or whatever, just go ahead and reset on all 5 copies, or however many copies there are. State doesn't have a 911 requested by defense 4 weeks ago, or whatever. You should be subpoenaing your 911 people, but a practitioner for another day. Yes, ma'am, go ahead, Commissioner Pearl.
Judge, I've only been in your court for a plea, and I've seen this going on now for a while. There's nothing personal. It seems like a cluster to me, okay?
Like me, or?
No.
I'm being serious, like, I need to know how to frame what you're about to say.
The process seems like a cluster, because if I'm in there at the 10 o'clock setting, trying to handle my 10 o'clock included courts, I'm sitting there still competing with lawyers that held over from the hour before. Everything's just rolling over until later, and the prosecutors don't have as much time to talk to you and deal with you.
Right, and I agree. I know in my court that one of the specialized prosecutors typically comes up. We also have a bar card intern who can just stand at the bench and take pleas and stand there for whatever conversations they need to be present for, but not really lawyerly interacting. What I would suggest is, you're absolutely right, and there's no way for me ever to fix with the volume of cases we have on any docket, whether we do it the old way or the new way, for you to have a really good opportunity to plead your case in the court to the DA, which is why I don't know why this stuff wasn't on the internet before, but, and any other ideas that any of you have about how to make the process easier for you all and more interactive, I'm completely open to. Judge Patrick and I might be the only ones who can turn on a computer in the courthouse, but we're very encouraging of the others to do things like this. That's why the system works theoretically, and I get that it requires the answering and the response from the DA's office, but if everybody's communicating and negotiating outside of court.
What I would suggest is having a scheduling order on the very first day, to where you have a scheduling order that says here the DAs are required to exchange this information by this time.
I don't disagree that that's a good idea. The problem is that requires control over agencies who are gonna thumb their noses at me. I mean, HPD is not gonna listen if I say you have to have those drugs tested by 89 days.
I'm just saying to have a scheduling order, talk to them in the truncated time that you have, in the court when they're handling all these cases, if you have scheduling order, like they do in some courts in federal court, that everything that you need would be on there, and if it's not, and then when you come to the next setting, deal with it.
I'm open to it. I'm open to the idea. Dawn.
This might be too progressive, but, I think right now defense lawyers are not, we're generally not in the positions of strength compared to the prosecution, compared to the law enforcement. And so they can string stuff out, we're the ones who can